It's a very salutary week, actually, for any of us involved in risk. So although we put, what you will see later on in the slide, we put up some figures. I introduced this slide a couple of days ago but for obvious reasons, and obviously there was a question asked about it just now. And I've stood with clients. I remember last time I think was in Telford Crown Court 18 months ago. And obviously if you've been in Stafford Crown Court this week, it's a very sobering experience, and there was talk about crisp shirts and ties, and I imagine that lawyers will often be, if I've often advised clients about how they should dress and turn up, whether it's the HSE or anyone else coming to a meeting. But this is obviously a very tragic situation, life-changing injuries, obviously. But in a way, what I'd say about this week is that it tells you a lot. It's a really interesting case study about life for corporates in 2016 Britain and the challenges that they face. Some of the bits that you may have missed, I mean, the headlines were there in the Daily Mail or its paramilitary wing, the Daily Express, just about numbers. But actually, once you delved into it, there were some really interesting pointers for all of us in industry as we seek to manage problems and challenge. And what was really interesting is they went back, the court was very interested to find out that 3 years before the Smiler accident, somebody had died in the moat at Warwick Castle, which, as you know, Merlin is also part of their empire. And the judge was very clear, that was a golden opportunity to make changes to health and safety systems, that incident in 2012. Now, the judge did say some comments that, of course, didn't get reported. Merlin does have a good health and safety record and procedures in place, particularly given its size, so that was interesting. But Warwick was an aggravating feature so far as the court was concerned, because there had been a failure to carry out risk assessments in 2012, and these are the judge's words, those words should have been ringing in the ears of Merlin when it opened Smiler 6 months later. Now, in my world, the legal world, you can usually tell how things are going when you hear about where the status of things are. So obviously the compensation process is plainly not finished with Merlin, and you had Stewart's Law or claimant work out on the steps of Stafford Crown Court. So this will run on for some time. Very expensive, obviously taking an awful lot of money and time for that business. But then when a judge describes your business and the approach as a shambles, and it shows a lack of a structured approach to ensuring the track was safe, you've obviously got a lot of work to do. And then somebody on the PR side put out a press release last November that it was due to human error. That went down very, very badly with this court because, frankly, that was not right in the court's view. It was not down to human error. It was obviously down to that was definitely not the cause. It was a lack of a structured approach to ensuring this track was safe. Now again, in my world, I know the barrister who defended this reasonably well. We do work with Simon quite a lot. And he had a tough time because if you're a director or a senior manager in this room, we talked about the £5 million fine, but the judge, when he wants to know quite a lot of information, not just about the turnover of this company, he wants to know what the directors were on. And in fact, he said to Simon, I want to know what the share options are of your directors, please. And Simon said, I don't need to tell you that. That's not what the rules are about. And he said, you need to go away. I'm going to stand up now, and we're all going to go out the door, and you're going to go and find out this information. It was it's a very salutary lesson, as I say, for directors, the people in the crisp shirts, to think about these. And when he came back and answered those questions about share options, the judge said, look, the prospects seem quite rosy for these directors. This accident doesn't seem to have much impact on them at all. And so, because we get involved in troubleshooting quite a lot, 2 weeks before they pleaded guilty in April, they set out their share options, no connection at all with safety. So I would suggest to people, when you're looking at your remuneration reports and your share options and so on, you should be tying that to safety. Otherwise, you'll find yourself on the reputational side getting probably knocked around quite a lot in the press. So let's get started anyway with what we were going to talk about, which obviously is particularly related to COMAH. Always the technical details that people like. So of course we have the control of major accident hazards regulations in 2015. made on the 2nd of March last year and come into force on the 1st of June last year. So quite simply, what do? They set out the rules for the prevention of major industrial accidents and obviously the limitation of the consequences of any such accidents. Right, now I should just say one thing actually, obviously bearing in mind what happened over in Manchester Town Hall on the 24th of June this year, you might have noticed it on the news, obviously we're leaving the European Union, and obviously a lot of the regulations that come through COMAH of course ultimately come through European directives. My take for what it's worth is that what the rules that are here to safeguard us in relation to this sort of work aren't going to go anywhere in a hurry. I know we got invited into a Treasury meeting earlier this month, and the focus is very much on financial services. No one's really looking at some of the wider bits and pieces from what we can see in terms of regulation at the moment. So I can't see those sort of things changing any time soon. So when, as a lawyer, you get called in because there's been a problem, there's a real sort of number of obvious interactions on the legal side and the COMAH side. And from a troubleshooter's perspective like mine, if there's been an incident, we usually get involved afterwards and commence an investigation. Now, this is a really difficult time, I appreciate, on the internal side, but the full understanding internally is absolutely crucial. And one of the things where we can occasionally have, dare I say it, tension with David's colleagues in HSE is around those investigations, because as lawyers, we're able to use privilege, legal privilege, to do a full investigation and really seek openness from a client about what's happened. So really sort of open up and be very open about what the issues are, because some of that information should not, if it's covered under legal privilege, be shared with the HSE. And that can often encourage people to get the right information at the right time and take a position on what they want to do in relation to any HSE prosecution. So David's very kindly already just reminded you about who the competent authority is for these purposes. Obviously, largely it's can be represented by the HSE, but obviously for the ONR if it's at a nuclear establishment, and they will work jointly with whether it's with the Environment Agency, the Scottish Environmental Protection Agency, or Natural Resources Wales. But obviously we tend to see, as I think David indicated, an HSE lead. So John, I think you're going to pick up from here on the objectives when we see them from a sort of legal perspective.
It was interesting to hear from David, because there are quite a lot of common themes in terms of what we're talking about and what David was bringing up in terms of what we've seen with COMAH compliance at site level. So, competent authority objectives, they are what they say on the slide. The two at the top are important, and they link nicely to David's slides about the importance of leadership in this arena. Very important, both in the context of what Colin was talking about, the new world of fines and sentencing guidelines, which we'll come on to later, but also in demonstrating that you've got proper safety management systems and performance in place. I certainly think in our experience we often see leadership doesn't get too much involved. Maybe it's maintenance and engineering departments that drive this stuff, and the wider piece about thinking of budgetary planning and proper resourcing of these elements isn't always top of the tree. Well, we're in a different world now in terms of when people end up in court on the criminal and the civil sides, and the clue's in the title of the regulations, isn't it? Major accident hazards. That's top priority stuff. Again, there was mention of monitoring standards, existing emerging technologies, the good practice. The world doesn't stop. I think it was Lord Denning said, the standard goes up as man becomes wiser. You know, what was good enough 5 years ago may not be seen as all necessary measures now. So you've got to keep an eye on that as an organisation. The changes, you're probably well aware of some of the key ones in terms of the lower tier and upper tier classifications, which are nicely in Schedule 1 if you want to read of them. But just looking at some of those aspects and what we've seen, upper tier, as David said, red categories are going to come and visit you, but we've seen quite a few clients who have just nudged into the lower tier stuff. Storage of aerosols, for example. the shed, as our client put it. Yes, well, your shed's a bit different this year because it now comes under this. What that did for them is bring them under much greater general regulatory scrutiny because the Environment Agency were interested, Fire Brigade were interested. HSE, obviously, it's on there as a lower tier site now. Maybe the general inspector's a bit more interested as well. So, by one small thing on your site, small changes in categories, it can have a significant aspect on your risk profile and how you should think about managing that. And that links to the bottom piece really. Yeah, manufacturing of stuff, everyone understands that. That's a big piece. But the storage element, I still think, there are probably a few people out there who may not have fully grasped that yet, shall we say. Public information. Information in the public domain. HSE has a web-based system for you to enter that. I printed off the guidance. I suggest you read it before you enter your information. The important stuff with this is it is in the public domain, so anyone can look at that. Neighbourhood communities, pressure groups, not just enforcers. So when you enter that, make sure it's right. Effectively, that's a statement of fact. If you put it on there, that's what you're standing for as an organisation. So you need to make sure it's right. Print it off and read it before you press a button. Safety management systems. I've covered the top point about are you leaving things just to the maintenance or engineering department? How much interaction does senior management have with this stuff? David made a really good point. Something goes wrong, the shirts and ties come out. How could this happen at our place? Well, maybe you should have been paying a bit more attention, asking some of those validity questions. All familiar with INDG 417? The HSE's in the room, I suggest you nod your head. Yeah? Don't see COMAH as a separate piece. It's part of your overall risk profile. So the same stuff that you use to manage general health and safety management, board information, all that good stuff, that should just apply to COMAH just the same. And it should be in the round. When you're looking at resource, finance, budgets, you've got to be thinking about those things. They don't just stand alone. We tend to have quite a lot of structural and organisational changes these days, don't we? Mergers, takeovers, acquisitions, call them what you will. Your systems have to catch up with that type of stuff. And again, if you're in the acquiring business, the day you take it over, you've got responsibility for those sites. So, that all necessary measures hit you the day after. So due diligence is quite a good thing to remember, I think, if you're involved in that end of the market. Well, we would mention external consultants because they're here today because of us, aren't they? The important thing there, and it links back to a point that David made, is don't think that an external consultant is guaranteeing you COMAH compliance. The pressure systems point was a very good one. There are differences between what you need to do under PSSR and what you need to do under COMAH. We've certainly seen, and it links back to the 2011 stuff when the HSE went out on sites, of clients being served with improvement notices because they thought a consultant doing pressure inspections was really managing some of their asset integrity stuff as well, and they weren't. And it's the organisation that runs the stuff that has to satisfy the competent authority. So a message there, many places need consultancy support, but understand what you're getting from them and what you want that to achieve within your overall compliance program. It's not just about box ticking. And obviously that may change from year to year, asset management plans, etc. And again, as David said, it's not just about having a system, what's happening out there? If someone had gone and looked at that very interesting piece of carbon steel that David had on his slide, they might have spotted something wrong with that and wanted to do something about it. So talk to people out there that do this stuff. What does the plant look like? It's not all about management systems. We've had plenty of examples, not specifically COMAH related, where people have nice management systems. You all got ISO and OSAS accreditations? You're not allowed to laugh. That wasn't a joke. The point is, those things don't necessarily mean you're taking all necessary measures for a COMAH perspective. You need to think about those things and what the validity is of those aspects. Budget planning, yeah, the bullet on the slide says it all. But, you know, back to Colin's point about, you know, Merlin prosecution, we have noticed finance directors are taking a bit more notice of health and safety now. You stick a nought on the end of the fine, they take a bit of notice. That may be sad, but that is to some extent the world in which we live. Now, we have to have a lawyer to talk about breach of contract, so I'll hand back to Colin.
No, I'm definitely a lawyer, because when you go to law school, they say you cannot have a striped shirt, whatever you do in life. You can't have a striped shirt. Right. So breach of contract. I put this down as sort of covering the civil law slide. We're going to come on to the criminal law slide in a second, but really just those things that just come up when you have an incident and you need to sort of work it through. Now, as Andy indicated, I've obviously spent a lot of time in the insurance industry, and the insurance industry is about, I think it's now into the 20th century, but it's a bit behind everybody else in terms of the way it operates. But what it does, which means it's quite a difficult, challenging process to get your claim paid, and that's particularly the case if you've got a COMAH-induced plant shutdown, because business interruption is very expensive. If you buy it, you would know that. And it can be a very challenging experience to go through to try and get your recovery, to make that finance director happy who's already worried about a potential fine coming in. So some of the things I would always just alert people to, if you're going to buy business interruption cover, is you will then get the army of loss adjusters appointed by insurers, which have their own challenges because they're looking to, I can put this politely, manage the size of the claim. And gross profit calculations are one of the biggest challenges I can tell you on business interruption claims, and often you find there's a lot of underinsurance because, as John indicates in a different context, people's businesses evolve, the numbers evolve, and yet often the other things don't really catch up. So do we always be very wary of where the loss adjusters are coming from? You've got an obligation usually to mitigate your loss. So you've got this big sort of civil issue coming down the track, and you need to think very carefully about it. Now, with the length of the indemnity period is also very important in business interruption, because people often don't think, actually, in my business, if I had a shutdown, how long is that actually going to take because of the nature of my business? And some COMAH sites would plainly be down, obviously, for quite some time indeed. I put up there about supply chain implications, because I've been very struck, depending on the size of your businesses, how PQQs and our friends in procurement are becoming more sophisticated in their questions. So what were questions 5 years ago? Have you ever been convicted of an offence under the Health and Safety at Work Act? They've obviously cottoned on that there aren't that many convictions, but there's lots of prosecutions, there's fees for intervention, there's all sorts of things in between. So we've found in a lot of the PQQs that we advise on much broader questions around where you might be getting interaction with the HSE. I mean, fees for intervention in particular, I know one particular procurement outfit within a major retailer, who I won't name, but asking very, very pertinent questions about the number of fee for intervention payouts that have been made. Now, in relation to insurance itself, and obviously I imagine many of you will be familiar with employers' liability insurance. Obviously that's there to cover your employees in the event of personal injury and the like. But of course there's also probably the biggest thing you probably pay for may well be your public liability insurance. It's there to cover your civil liabilities, cover possibly the personal injury and so on claims from third parties, which I'll touch on in a second. Damage to property, possibly usually other people's property, and also dealing with nuisance claims. So insurance potentially could be a very, very good risk mitigant, but as I say, the claims process can often be not straightforward and very, very distracting for management time. So what we usually advise people to do when they've got one of those major claims is separate out the management team or the board, however you're operated, to have someone just focus on the insurance, because insurers love nothing better than when you're distracted trying to deal with a major problem over here, to then make hay and get the loss adjusters asking some difficult questions. So always having somebody on the board or the management group who's focused on this is quite important. It will have an impact on your renewals, but that's not quite the way to look at it. Insurers will price for a whole raft of reasons. So always try and be as upfront as you can and proactive with your insurer. And I know that some people have been concerned recently where they're in a chain of suppliers, and the insurer is then trying to subrogate paid out claims against against some of the other members of their supply chain, which can cause some difficulty. You can try to get agreement up front about subrogation if you wish. It's probably worth just touching about management time and directors' duties generally. So, like all things, as John says, directors' duties just expand as the years go by. And their applicability to senior employees only tends to grow. So one of the things that we are seeing is more demand for directors and officers insurance, D&O, simply because it's a good risk mitigant on a personal level. And when we do presentations at our offices, we talk about lots of things, and they're all very interesting, and we get lots of people. But when we talk about things like D&O, which is very personal, we get a bit more interest, because obviously we all know when we take on these jobs and become a director, we're taking some personal risk. I've been working for a while on a claim in the automotive industry, which you might have vaguely read in the paper. There's been a few problems with emissions testing. But it's an area where you've got lots of similar issues around the management of systems and controls and failings and groupthink type challenges. So I would say, if you can afford it, do look into D&O. The D&O insurers are really trying to push into particularly the SME market at the moment, because it's quite a good risk mitigant, because usually they will provide you with some form of cover that if you are subject to a individual action, and that can be from shareholders or regulators, disgruntled employees, there should be some cover for that. So as a risk mitigant, definitely worth thinking about. But I'm afraid directors' duties only tend to be increasing. We've just put in there the very obvious thing, because it's the thing that obviously gets in the paper, understandably, around personal injury and death. Multi-action, lots and lots of parties, lots of earnings claims, medical bills, and ongoing support. It has a real knock-on long-term consequence for many businesses when they get personal injury claims, which is why so much goes in from HSE and others to try and prevent these actions in the first place. I just wanted to just remind us for a moment just about where criminal prosecutions come in. We're all very familiar with Section 2, that's the general duty of employers to their employees under the Health and Safety at Work Act, and of course Section 3, the duty of employers to persons other than their employees. COMAH obviously gets its powers from the Health and Safety at Work Act, but I wanted to highlight two things, because actually this is, when we talk to companies and all sorts of people at all sorts of levels within companies, it does get a bit of attention. So I always try and show them Section 7, which is the duty of every employee to take reasonable care for the health and safety of himself or herself and other persons who may be affected by their acts and omissions. Now, you don't get a lot of Section 7 prosecutions, but they apply to everybody, whatever level you are at. If you are not taking reasonable care for yourself and for others, you can be subject to a prosecution. So again, trying to make people think about that. Section 37 is probably for the people slightly higher up the food chain, because this is again an offence that it's used more commonly now by the HSE, but it ties together the corporate and individuals, because now if you can show that the offence has been committed with the consent or the connivance or attributable to the neglect of any director or manager, then they are both deemed guilty of an offence. So it's a very useful provision of the Act for HSE when it comes to seeking prosecutions, and that's why they've looked more and more into actually who were making the decisions. If the finance director decides that he or she thinks they can deal with, that they can cope with half the number of maintenance people that they had last year, I think they're taking quite a bold step there for them personally. And I think that's where Section 37 is definitely worth reminding them. Now, we talked about Alton Towers. There was a question about it. So obviously we hadn't put it in this section, but I just want to give you a bit of a feel for the sentencing guidelines that changed or evolved a bit further on the 1st of February this year. You can't, as David says, put value on a life, but just want to give you this statistic. You can see, obviously, you may be familiar a few weeks ago that rail, obviously in the rail industry, Network Rail, a £4 million fine for the death of a member of the public on a level crossing. 4 million happens to be exactly the same number that Railtrack received in 1999 for the deaths of 31 people at Ladbroke Grove. So over those 16 years, and these sentencing guidelines, which have changed some time, you can see where the numbers are going. I think this one, the energy sector one, I think our firm's actually involved in that, and that's currently going to appeal. Again, you've got the scolding of an operative, a £1.8 million fine. And it's that whole point, obviously, that you've heard about. It's about the risk rather than necessarily the outcome and the actual harm that courts are really getting their teeth into now. I've put another one up there about an 800k fine for an operative who was struck and dragged under an individual. And really, I think some of these numbers now, I think the courts are really getting their heads around them. So they've got a step-by-step approach, which they're finding much easier to follow. So first of all, where's the culpability? Then they look at the seriousness of the harm risked and the likelihood of harm. And then I'm looking at putting that into levels, about high and medium. And then looking at this assessment of turnover, which is where the finance directors come back in again. But it's all to provide a starting point for a fine, which is intended, and these are the words used in the Thames Water case, if you know that just the other year, which is to bring home the message to the directors and shareholders of offending organisations about breaches of Health and Safety at Work Act. Because the £1 million fine is really becoming quite commonplace now. So in January and February we had CRO Ports, they had an arm injury, they're a £25 million turnover business. They got a fine of 1.8 million, it's a lot for that side of business. Balfour Beatty had £1 million for a fatality. National Grid Gas, they had a broken leg, £1 million on a 3 billion turnover because of the risks that they had been ignoring. UK Power Networks had a fatality, 1 million again on a 1 billion turnover. The first one actually was ConocoPhillips after the 8th of February, which is the first one. They've got a 4.8 billion annual worldwide turnover. And they broke they had three health and safety regulatory breaches because there had been a series of uncontrolled and unexpected gas releases at an offshore installation, and the workers were sent to investigate when the gas was still present. Now, no one was injured, but there is where the focus was on risk, £3 million fine. Even though that particular business actually had suffered an £85 million pre-tax loss. So, culpability, absolutely key, and robust systems, yes, but are the robust systems being used? Now, one of the questions I often get asked is about the corporate veil piece, particularly if you're owned by a much bigger business, private equity or whatever. Now, what the rules say about that is that information relating to the organisation that's all that should really be before the court, but exceptionally, if it can be demonstrated that the resources of the linked organisation are relevant, they will take that into account. So just sitting in a small subsidiary isn't going to be enough. So as I say, the picture, in fact not just the picture, because you can see these real cases coming through, and this week was absolutely one of them, is obviously about higher fines. John, I know you were just going to give a couple of thoughts before we finish.
Yeah, thanks, Colin. So, what do we need to remember today? Build COMAH into your overall health and safety management strategy. We've mentioned INDG 417. I think David had up in his slide leadership from the major hazard industries. INDG 277. You know, that's good HSE guidance out there. Take account of it when you're designing and implementing your systems. Don't rely on others to do your job. They can help you get there and assist you. You still hold the legal accountability and need to recognise that. And when you're dealing with a competent authority, that's a long-term relationship. David outlined the type of approach they take in terms of how often to visit, interventions, inspection regimes and plans. Build that relationship so you know what's coming, and also take the opportunity to speak to each other. You know, what's going on in the, you know, what attitude have inspectors got, what's happening, keep that market intelligence going. That's important both from a regulatory perspective, but also from protecting your business. Thanks very much.
I mean, I think one of the things for lawyers which we have an advantage on is we can always work backwards with what we can do because we have the benefit of hindsight. And the number of times I've gone into businesses, got out the emails, and then seen someone's face fall when I said, "Can I have your texts, please?" Because there's still a perception that texts and emails are somehow different. So when it comes to getting out information on an investigatory business, we've got lots of reports, we've got video footage. There's lots of rich pickings now, particularly for prosecution lawyers, wanting to sort of play around with how robust your system really was on the day. But ultimately, obviously, what everybody in this room is interested in is obviously the business for avoiding days at Stafford Crown Court, like Merlin had this week. But as I say, you can see that the direction of travel is only going in one particular direction.